Hi, my name's Emily Rucker and I'm a partner here in Warner's Grand Rapids office. My practice focuses on supply chain litigation and dispute resolution, and today I want to talk to you a little bit about what I call contract performance hygiene. So our clients spend a lot of time negotiating contracts, getting them finalized and buttoned up, but once those contracts are signed, sometimes they can go in the metaphorical drawer and they don't necessarily get pulled out to be reviewed regularly. And that can lead to problems when it comes to disputes that crop up. For example, many contracts provide that in the event of a breach, one party needs to give notice to the other party within a specified period of time, or maybe if no time is specified, within a reasonable time. If those notices aren't given at the time when the breach occurs, then it may become something your attorneys need to explain later in litigation and can pose a problem. Many contracts provide that one party needs to make a choice between a set of options. For example, if you received a defective product in a supply situation, you can either return that product or pursue the seller for damages. Or maybe you can repair it or have the seller repair it. If those elections aren't made at the time the issue comes up, then an otherwise simple dispute can get complicated and quickly become difficult to resolve. It's important to be aware of the duration of your contracts. When do you have to give notice of renewal or non-renewal? When can the other party give notice of renewal or non-renewal? If you're not paying careful attention to these time periods, then instead of going into contract negotiations with your eyes wide open, you could be caught unawares by a notice from the other side. So how can you prevent these common issues? First, make sure you have a centralized repository and filing system for your executed and finalized contracts, including all of the associated terms and conditions, exhibits, or other associated documents that may affect the party's obligations. It sounds very simple, but many times, especially if your organization has experienced turnover, you'll find contracts on some people's email inboxes or some people's laptops, and not in one place that everyone can find. So take that time to create an easy-to-use, centralized system that everybody can get to when they need it. Second, make a note in a central location of any periodic obligations you might have under that agreement, including the contract's term and any non-renewal dates. Make sure that document is accessible to anyone that has responsibilities related to their relationship and that those people know where to find it. Third, set a schedule to periodically review your agreements. How often you do this will differ depending on your organization and the number of contracts you deal with on a daily basis. But having somebody familiar with the relationship of the parties actually take out the contract and lay eyes on it can go a long way towards preventing disputes and minimizing them when they do occur. Finally, if trouble does arise, even minor trouble, be sure to pull out the contract to review the notice requirements. You may decide not to give notice of breach, but at least that will be a conscious choice instead of something your lawyers have to explain later. And if you are in a breach situation, be sure to call your Warner attorney for advice. We can help maximize the potential of success in litigation and minimize the potential that litigation occurs in the first place.